must say that speaking for Europe, because we are here dealing at the General Court of the EU, more or less with actions which concern different member states of the European Union, or more general, everything that's happening in Europe, we are having a lot of cases where internet is at the main point, or where the stakes are high. To make a first statement, I would say that currently the most important thing which we, in my view, have in Europe is not only about the competent court, so as in the IMS-NIV, or in this case I mentioned Lenin, but also as to how to accept extraterritorial elements of proof, or proofs which are purely on internet. In these cases, which are very recent, I would maybe mention the Louis Vuitton case from this October 22, which is T27521, and two other Tequila Revolution, the T62821, plus Standard International, the 76820. All of these cases are in fact developing the case law on what do we accept and what do we not accept. To make it very simple and without going into too much details, the Louis Vuitton case, which concerns a graphical element, the checkboard pattern, there were questions whether consumers in states like Slovakia, I'm from Slovakia, so it's very interesting for me to read, or from Bulgaria, have a knowledge of such a trademark, which is sufficient, so for a substantive amount of the public, giving them the privilege to understand that it is a trademark. And to see what's going on, it's very well developed in points 80 and further of this case that we are in the new world, as you mentioned, Iris. So it's really that internet can today be the decisive thing for the consumers. They can, in fact, understand that something is a trademark, or there can be trademark infringement by internet, but still some conditions have to be met. And these conditions, I think now we have clarity on some points, is that for a distinctive character acquired by use, you really have to show how much of these consumers you are able to meet in these territories. It's really about seeing what are the analyses of the technical features, how much of the pages were opened, whether there are some reactivities of the consumers, whether you have really a percentage which is sufficient to be considered, to be taken into account by each territory. So this is one point what we analyze usually. It's very much linked to the language of the web page, to the fact whether the currency is the currency of the state, so we can see what is focused by, or who are the customers focused by such an advertising. But you can also take into account if it's page .com, .eu, or if it's really on the internet of the national server, which makes it more easy to understand who is focused on. On the other side, we also have situations like in the hotel case, the Standard International Management, where the question linked to genuine use of a trademark is really not so much about the services themselves, which may be, for example, proposed in the United States of America, but it is more about how you show that the publicity for these services are done in Europe. That means that you really have a genuine use in Europe, although it's not the service itself that is physically proposed here, but you are searching for your consumers. So this is also very important. And the last one, because I don't want to make much of a speech, the last one, like in the Tequila cases, it's also something which is very open. It's how you take into account of elements of proof, which seems to be focused on a global public, for example, a mondial public who goes to YouTube to listen to some music or video recording, if there is some publicity for a specific product, if at the same time you don't have the proof that what was virtually really focused on was a publicum or a customer in the European Union. So these are the elements which are still developed. And I think, for example, this order for reference in the case C-104/22 is very interesting. We will be waiting for the Court of Justice to give its opinion, which will be definitely important. In one sentence, there is a question whether companies in Germany, which might be advertising some products in an aspect without details and in English, which might seem as focusing on any client in Europe, whether they are by this way causing infringement to a trademark which is owned by a company in Finland. So it's really a question of how much you must show to be clearly focusing on the territory where an entry trademark is protected. So this is maybe for some introduction about Europe. Thank you.